Hi, I'm John Hayes. I'm a certified bankruptcy specialist in Southern California. I'm a partner in the bankruptcy firm of Resnick Hayes Maradi, and I'm a adjunct professor at the University of West Los Angeles School of Law. I'm teaching my basic bankruptcy class this year, the spring of 2021. And we've been talking nonstop about what is property of the estate, what assets are there that the trustee can take. And this video is designed for my students, so it has some sort of technical detail of it. And it's also designed for new lawyers or new attorneys who aren't so new, who are thinking about getting into practicing bankruptcy law. So the question that I'm going to talk about today is leases. Most commonly, it comes up in the context of automobiles, auto leases, but it also applies to equipment leases and even to property leases, apartments or even commercial property. And the question that comes up is when you're leasing a car, is that something that the trustee can take? Can the trustee sell the car if you're leasing it? And I'm going to give you a practical answer now. A legal answer now, and then at the end of the presentation, I'll give you a practical answer. The legal answer is absolutely. Well, how can that be when you don't own the car? Ford Motor Leasing, Toyota Leasing owns the car. How could the trustee possibly sell that? So we have to start by looking at the bankruptcy code. The bankruptcy code says property of the estate is all legal and equitable interests of the debtor in property wherever located at the time of filing the bankruptcy. So all legal and equitable interests in property, right? So yeah, the debtor doesn't own the Mercedes that he leased. Mercedes Leasing owns it. But the debtor owns the lease. What does that mean? The debtor owns the right to possess the car, drive it around, impress everybody. And in exchange for that, the debtor has to make payments each month. And if you look at the lease has lots of things in it. It only so many miles, you have to take care of it. You have to bring it back by such and such date. You have to make payments each month. So owning the lease is combined with the duty to do whatever's in the lease. So can the trustee sell the lease? That's what it comes down to. And the answer again is yes. The lease may say that the debtor, the lessee, can't assign the lease to somebody without getting Toyota's permission. And I'm sure it says that. And if it says that, that's binding on the trustee. The trustee would have to go get Toyota's permission. But Toyota can't, unreasonably prevent the assignment. So why would anybody do that? Well, the answer is somebody would buy that lease if it had value. So how would a lease have value? How would an auto lease have value? Whoever accepts the assignment of the lease, whoever takes over that lease, is going to have to agree to Toyota that they'll be bound by all of the terms of the lease. So whoever's going to buy the lease from the trustee would have to make the monthly payments thereafter. If the payments are behind, that person would have to catch them up. That person would be subject to the mileage limits and whatever other promises that the debtor made in the lease. So the only way anybody would buy the lease from the trustee is if the total amount that had to be paid under the lease was worth less than what the car is owned. Even then, if the lease says you got to give it back, you don't have any choice. At the end of the lease term, you must give the car back. Then all the person buying the lease is going to get is the right to use that car for however many months are left. And that person would have to pay the lease payments for that many months. So it's still maybe it's equipment. A doctor or something is leasing some particular equipment, and maybe the equipment has gone up in value or something. So a new lease now would cost more than what the person would have to pay under this old lease. If that's the case, the trustee could sell the lease. Technical term is assign the lease to somebody for some amount of money. So the person getting the equipment and accepting the lease would pay some amount to the trustee and then pay whatever the lease requirements are under the lease that's being assigned. All right, so that applies also to leases of real estate. Could be an apartment. It could be commercial property. Again, this doctor. The doctor is operating as a sole proprietor. The doctor is leasing space. The trustee could sell the lease, the right to possess that piece of property. Who would buy it? Who would buy the lease? Well, somebody wants that space for one thing, and maybe the next door neighbor. But somebody also might buy it if the payments under the lease term are less than what the going rate is, the going market rate for that piece of property right now. So how does this work in Chapter 7 though? Because we have a trustee and we have, debtor keeps driving the car around. How does that work? And we know that if you own the car and you are making payments to the secured creditor, whoever loaned you the money to buy the car, the debtor is required to reaffirm the car loan or give the car back. The debtor has to make one of those choices. How does that work when it's a lease? So the answer to that is in Chapter 7, it's really all I'm talking about, but in Chapter 7, the discharge, most people file Chapter 7 to get the discharge, wipes out all their debts. So the debts under the lease, the duty to make payments, the duty to make a payment at the end of the lease, the duty to only drive it so many miles, to take care of it, keep it in reasonable condition. All those promises made under the lease are all instantaneously discharged. All right. So where does that leave Toyota? Where does that leave the leasing company? Right. Well, they could actually charge the debtor the value of using the car after the bankruptcy is filed, and continuing to drive the car would create a new debt. How much would the debt be? The value of using the car. It could not be measured under the terms of the lease because the lease obligations are discharged, right? So Congress has listened to the poor old car leasing companies I say that sarcastically. And Congress has said, yes, debtor, first of all, we have to see if the trustee is going to sell the property. The trustee gets a certain amount of time to sell the lease. If the trustee doesn't sell the lease, then the debtor can assume the lease himself or herself. So how do you do that? Well, the debtor has to enter into what's called an assumption agreement. And what happens is the leasing company will send an assumption agreement to the debtor. And if the debtor signs the assumption lease and sends it back to the leasing company, it's automatically assumed, meaning the debtor is now liable again for whatever obligations, whatever financial obligations are in that lease. There doesn't have to be a court hearing. There doesn't have to be approval of the assumption. It's automatic. It's called Section 365P. So the practical effect of this is that I've been doing this for 40 years now. I've easily filed 1,500 Chapter 7s. I've certainly have overseen probably twice that many. Never seen a trustee sell a car lease. I'm not sure I've ever seen a trustee sell an equipment lease. Usually the equipment isn't worth the amount that's still owed on the lease anyway, but I generally also don't see leasing companies beat on the debtor about assuming the lease. In other words, resurrecting the debts that are inherent in the lease contract. But the debtor keeps making the payment, keeps driving the car, and what difference does it make? I'd say though, unless the debtor assumes that lease, signs something saying, I agree that the discharge doesn't apply to you, Toyota. I agree, I'll do everything that's in that lease agreement. Unless the debtor does that, the lease contract is discharged. The debts under the lease are discharged. When the debtor keeps making payments every month for the rest of the term of the lease, that does not resurrect the obligations under the lease. In other words, most commonly the mileage. If there's a mileage limitation, you have to pay more if you go more miles. That's discharged unless the debtor assumes the lease, meaning signs an assumption. And again, when the debtor signs the assumption, it's automatically resurrects all of the debts under the original lease agreement. I've certainly never seen it in the case of a debtor's apartment. I've never seen an assumption. I've never seen the trustee sell it. So that's leases, how leases work in Chapter 7. If you enjoyed the video, click like on YouTube. And I have 2 partners. Our firm has 7 attorneys. 4 of us are certified bankruptcy specialists. In California, we're not much good at giving advice in any other states. But if you have questions, put your questions in the section below the video on YouTube. And thank you for listening.